In New York City, most tenants are paying their rent without understanding the legal framework that governs that payment. The protections built into state law are real, specific, and frequently unused, not because they are obscure, but because nobody explains them. In a city where the median asking rent reached $3,585 in the fourth quarter of 2025, the cost of that ignorance is not abstract. The relevant law is the Housing Stability and Tenant Protection Act, known as the HSTPA, which took effect on June 14, 2019. Within it, Real Property Law Section 238A established a mandatory 5-day grace period for rent payments across most residential leases in New York State. The statutory language is direct. No landlord may demand any payment or charge for late rent unless the payment has not been made within 5 days of the date it was due. If rent is due on the first of the month, the grace period runs through the 6th. No late fee is legally permissible before that point. The distinction that most tenants miss is this: the grace period does not move the due date. Rent is still due on the 1st. A tenant who pays on the 4th is technically late. What the grace period does, and only what it does, is delay the moment at which a landlord may charge for that lateness. Those are two different legal facts. Treating them as the same one is where the confusion and often the financial damage begins. A tenant who consistently pays on the 4th, the 5th, or the 6th, month after month, is building a documented record of late payment. No fee is charged, no notice arrives, nothing appears to go wrong, but that pattern is recorded in the lease history, and it can surface when a lease comes up for renewal, when a prospective landlord runs a background check, or when a dispute reaches housing court. The grace period is a buffer against fees. It is not a revision of the lease's stated terms. Under Real Property Law Section 238A, the maximum late fee a landlord may charge is $50, or 5% of monthly rent, whichever is less. According to Apartments.com data from August 2025, the average rent in New York City was $4,031 per month. 5% of that figure is $201. Because $50 is less, the cap applies, and $50 is the maximum allowable charge. For rent-stabilized apartments, that $50 ceiling is fixed regardless of the rent amount. The New York State Bar Association confirmed this cap in its analysis of the HSTPA. Late fees are limited to 5% or $50, whichever is less. By national standards, this ceiling is exceptionally low. A tenant renting a one-bedroom apartment in Manhattan at close to $5,000 a month who pays on the 8th of the month owes, at most, $50 in late fees. Not a percentage of their rent, not a compounding daily rate. $50, one time. The law extends further. Under Real Property Actions and Proceedings Law, Section 711, a landlord cannot file a non-payment eviction petition based on unpaid late fees. A tenant who pays full rent each month but has accumulated late fees cannot be taken to housing court on that basis alone. The landlord retains the right to pursue those fees through a separate civil proceeding, but late fees do not constitute grounds for a non-payment eviction. Legal Services of Long Island has confirmed this protection in published guidance. There is, however, a mechanism that can turn an unpaid late fee into a larger problem. When a tenant makes a rent payment, a landlord is legally permitted to apply that payment to the oldest outstanding debt first. If a tenant owes $50 in late fees from the previous month and hands over the current month's rent, the landlord may credit $49 of that payment to the outstanding late fee balance, leaving the current month's rent $1 short. At that point, the tenant is technically delinquent on current rent. Legal Services of Long Island confirmed that this application of payments to prior debt is lawful. A $50 late fee, left unresolved, can create a cascading shortfall if the tenant is not tracking how their payments are being applied. Before the HSTPA, this legal architecture did not exist for most New York City tenants. Prior to June 2019, there was no mandatory statewide grace period for non-regulated apartments. Late fees were governed largely by whatever the lease stipulated, and leases are drafted by or on behalf of landlords. There was also no statutory cap on the amount a landlord could charge. The HSTPA changed that in multiple ways simultaneously. The 5-day grace period, the $50 fee cap, and a significant extension of the notice period required before a landlord could file for eviction. Before 2019, a landlord was required to give a tenant 3 days to pay before initiating a non-payment proceeding in housing court. The HSTPA extended that period to 14 days. Some landlords responded to these constraints by attempting to reconstruct them through alternative lease structures. The case of Biko versus Ritter is the most clearly documented example. Following the HSTPA's enactment, landlord Ritter sent tenants a notice proposing a rent increase of $375 per month, with the provision that tenants would receive a discount of the same amount if rent was paid by the 17th of the month. The structure was straightforward. Pay early and your rent stays the same. Pay after the 17th and you owe an additional $375. The New York State Bar Association reviewed the ruling. The court found this arrangement to be an illegal late fee in violation of Real Property Law Section 238A and held it unenforceable. The landlord appealed. The appeal failed. The court's position was that reframing a late payment penalty as a conditional discount did not change its legal character. That ruling has practical implications beyond the parties to that case. It establishes that the $50 cap cannot be circumvented through lease language that calls the charge something else. Courts have reviewed that argument and rejected it. The imbalance that preceded the HSTPA extended well beyond fee structures. Before 2017, the representation gap in New York City housing court was severe. According to figures compiled by NYU's Furman Center, 95% of landlords who filed eviction cases were represented by an attorney. 1% of tenants were. In August of 2017, Mayor Bill de Blasio signed Intro 214B into law, making New York City the first city in the United States to establish a legal right to counsel for low-income tenants in eviction proceedings. The income threshold for eligibility is 200% of the federal poverty level. Following implementation, evictions conducted by city marshals dropped 27%. As of the most recent reporting, 30% of tenants are now represented by an attorney in housing court. The Right to Counsel program has since encountered capacity constraints. After the pandemic eviction moratorium expired, the volume of housing court cases grew faster than the legal services infrastructure could absorb. The Manhattan Borough President's office documented the gap directly. Cases were being calendared at a pace exceeding the capacity of available attorneys, leaving tenants without representation. Despite the legal guarantee, the law remains in effect. Its implementation has not kept pace with demand. The eviction process in New York City, even under normal conditions, involves multiple sequential steps. After the 5-day grace period expires, Real Property Law Section 235EO requires a landlord to issue a formal written late payment notice before proceeding further. That notice is a legal prerequisite, not optional communication. If a landlord skips it and the case reaches housing court, the tenant can raise the landlord's failure to serve proper notice as a procedural defense, and the case may be dismissed on that basis. If the rent remains unpaid after that notice, the landlord may serve a 14-day notice to pay rent or quit. This document formally demands full payment within 14 days or surrender of the premises. After those 14 days elapse without payment, the landlord may file a non-payment proceeding in housing court under Real Property Actions and Proceedings Law, Section 711. From that point, the case enters the court system. In New York City, contested eviction cases move slowly. According to legal reporting reviewed by Pinpoint NYC, proceedings commonly run many months and frequently exceed a year from the initial notice to physical eviction. That timeline reflects notice requirements, mandatory waiting periods, court backlogs, adjournments, and the frequency with which cases are settled or resolved before a final order is issued. That timeline became more legally complex in April 2024 with the enactment of the Good Cause Eviction Law, effective April 20th of that year. The law applies to market-rate tenants in buildings constructed before 2009, rented from landlords who own more than 10 units. For those tenants, the law created an affirmative defense against non-payment eviction in cases where the landlord imposed an unreasonable rent increase, defined under the statute as an increase exceeding the Consumer Price Index, plus 5%. Beginning August 18, 2024, landlords were also required to include a good cause eviction law notice in every initial lease, every renewal, and every eviction-related notice, identifying whether the unit is covered, and, if not, explaining the basis for exemption. A landlord who omits that notice from a required document introduces a potential procedural defect into any subsequent court proceeding. The good cause law is contested. Attorney Phillips, commenting on its scope, described the law as protecting tenants in a gray area, those whose conduct might not meet the threshold for eviction for cause, but whose behavior a landlord would nonetheless prefer to resolve by non-renewal. His characterization was direct. The law helps tenants who are difficult and sometimes irregular in payment, but who have not given the landlord sufficient grounds for a formal court case. Tenant advocates describe that coverage as the law's purpose. Landlord groups describe it as a constraint on legitimate property management. Ann Korchak, board president of the Small Property Owners of New York, articulated the landlord position after the Rent Guidelines Board's June 2025 vote. The board's own data showed that the price index of operating costs for rent-stabilized properties, covering taxes, labor, fuel, utilities, maintenance, and insurance, rose 6.3% between April 2024 and March 2025. The board approved increases of 3% for one-year leases and 4.5% for two-year leases, beginning October 1, 2025. Korchak's statement, "We needed rent increases proportional with the 6.3% surge in building operating costs presented in the RGB's own reports. They didn't follow the math, and now these rent adjustments will further plunge small rent-stabilized buildings into distress and foreclosure. The tension between those competing pressures is genuine. Operating costs for landlords are rising. Tenant protections have expanded substantially over the same period. Neither of those facts alters the legal ceiling on late fees, which remains $50. The rental market context is relevant to understanding why these protections carry the weight they do in New York City specifically. According to the Realtor.com fourth quarter 2025 report, the median asking rent citywide rose 6.6% year over year, reaching $3,585 per month. In Manhattan, the median hit $4,886. At that figure, housing cost affordability, defined as spending no more than 30% of gross income on rent, requires a household income of $195,440 annually. Despite those figures, the city's population of renters is largely staying put. The same Realtor.com report found that nearly 90% of New York City renters remained in their unit from one year to the next. In the Bronx, that figure was 93.7%. Mobility in the rental market has fallen sharply, driven by the cost of re-entering it. The expense of first month, last month, and broker fees alone frequently exceeds $10,000 in higher-cost neighborhoods, making the prospect of moving economically prohibitive for many tenants, even when their current situation is deteriorating. According to 2025 records from the New York City Department of Finance, there were more than 966,000 registered rent-stabilized apartments in the city, representing approximately 42% of all rental units. Since 1994, 349,000 stabilized apartments have been removed from regulation. Net of units added through tax incentive programs, the citywide loss stands at 138,000 units, according to NYU's Furman Center. The Rent Guidelines Board has approved increases for stabilized units 4 consecutive years. Under Mayor Eric Adams, rents in the stabilized sector rose 12% in total. There is a category of rental history that operates outside the formal credit reporting system and that most tenants are unaware of. When a landlord or property management company screens a prospective tenant, they frequently access databases maintained by tenant screening services. These records capture late payment history, non-payment judgments, and eviction filings, including filings that were subsequently settled or dismissed. Industry professionals refer to this category of information as a shadow record. A formal eviction proceeding that never resulted in removal from the apartment can still appear in these systems and affect a tenant's ability to rent elsewhere. Within the formal credit reporting system, a late rent payment affects a credit score only if the delinquency exceeds 30 days and is reported to a credit bureau. Payments made within the grace period do not trigger that threshold. However, landlords and property management platforms that use rent reporting services may submit payment pattern data to the major credit bureaus on an ongoing basis. Newer credit scoring models, including FICO 10T and VantageScore 4.0, evaluate payment trends over time rather than individual instances. A consistent pattern of payments within the grace period, reported regularly, carries more weight in these models than a single late payment did in earlier frameworks. For tenants currently behind on rent and facing the prospect of a housing court proceeding, the city administers a program called the One-Shot Deal. It is a one-time emergency grant through New York City's Human Resources Administration designed to cover rent arrears and prevent imminent eviction. Eligibility requires demonstrating a future ability to pay, meaning the applicant's current income must be sufficient to meet ongoing rent obligations after the grant resolves the arrears. A tenant who received a one-shot deal for rent arrears within the prior 12 months is not eligible for a second grant within that period. The legal framework described in this report represents a substantial shift from the conditions that existed in New York City housing prior to 2017 and 2019. The Right to Counsel Law, the HSTPA, and the Good Cause Eviction Law collectively restructured the procedural and financial terms under which landlords and tenants interact in this city. The 5-day grace period is codified. The $50 late fee cap is codified. The 14-day notice requirement before a non-payment filing is codified. The prohibition on eviction proceedings based solely on late fees is codified. New York Real Property Law Section 238A. 5 days from the due date before any late fee may be charged, a maximum of $50 when it is. No non-payment eviction petition may be filed on the basis of unpaid late fees. A written late notice is required before any court proceeding. 14 days to respond to a formal non-payment demand before a housing court filing may occur. Using the grace period when circumstances require it is a legally protected option. Treating it as a routine payment schedule, month after month, creates a documented pattern that tenant screening services track, that landlords weigh in renewal decisions, and that housing court judges can consider as evidence. The distinction between those two uses of the same legal provision is not academic. In this market, at these rents, with this level of competition for stable housing, it carries material consequences.